Hi, I'm Scott, and I'd like to welcome you to the 2025 January-February LD Topic Lecture on the Treaties topic over whether the United States ought to become party to or ratify the Law of the Sea Treaty or the Rome Statute of the International Criminal Court. I want to start by noting that this video is almost 2 hours long. The reason for that is that there's something for everybody in this video, whether you do traditional debate or progressive debate, and the reason that this topic is really two topics in one. So there was a lot of material to cover. So because of that, I want to give you a brief preview here of what the video entails. I'll go through the definitions, the background, the history, and then a lot of different arguments. I behoove you to use the timestamps in the description below in order to navigate the video if you don't watch it in its entirety from the start. And I hope that you find this video helpful and that it provides you some level of success or knowledge on this topic. And I hope to see you in a future video. Thank you. The exact wording of the 2025 January-February Lincoln-Douglas debate topic is resolved the United States ought to become party to the United Nations Convention on the Law of the Sea and or the Rome Statute of the International Criminal Court. So let's get into the definition section of what exactly this debate topic means when we look at it. If we look at the key terms in the resolution, we're going to look at the United States ought become party to these two different treaties and what the meaning of and or is going to be in this topic. I want to first talk about the United States. I think in this topic that the United States is definitely going to mean the federal government, and I think that unlike past topics that there's not going to be a lot of ground for state-based arguments to be made because the nature of the topic, if we look at it from a holistic perspective, comes from the perspective of international treaties, and I just think that those agents are going to be incapable of doing the things that the affirmative is going to talk about. So I think that when we look at the United States, we're going to look at the Congress, the Senate, the President, things like that. When we look at the word ought, while I think that the word ought implies a moral obligation, I think that this topic is more of a policy topic where it's saying the United States ought to do something and that we as debaters ought to sort of role play as policymakers and say, hey, should this treaty be ratified or should it not be ratified? If we look further, I think that this talks a lot about the concept of fiat potentially, and I think that this is pretty interesting, cumbersome, maybe stretching the scope of things, but we'll talk about that in a little bit. If we look at the next word, I think that the phrase become party to is very interesting in this topic because a lot of treaties topics that we have had before in debate have, or at least the way that they have been worded when affirmatives have advocated for them, have used the word accede or ratify or join, and I think become party to is very interesting because it's going to mean that the affirmative is definitely going to have to do something. But I also think that it means that the negative is going to get a lot less ground for these process-style counterplans. So I think that become party to is going to be interesting because it means that the affirmative is going to be obligated to ratify or to get involved with or to make the United States responsible for the things that the treaty entails, but it does so without using this accede or ratify terminology, which in the past has opened up ground to a lot of negative counterplan arguments. I think the other thing that become party to is interesting for definitionally defining things is that it probably means that you can't partially do something. It probably means that you have to do this without reservations, which we'll talk about in a second, but it probably means that the affirmative can't conditionally advocate for becoming party to one of these two treaties. If we look at the next part of the topic, it has two different treaties in it. I will get more in depth on this when we get into the background and history section, where I will break this down. But to give you a brief little summary, both of these are international treaties. The first one is the United Nations Convention on the Law of the Sea. A lot of people will abbreviate this as UNCLOS or LOST. This is a comprehensive, unifying governance of the oceans that allows for respect of different nations, territories, different marine life, maritime laws, international ocean laws, deals a lot with how the environment should be treated in terms of resource extraction, in terms of scientific development, technological development, different navigational rights that different ships or different navies should have, and then, the different scopes to how the ocean would be regulated in terms of piracy, again, economic rights with mining and resource extraction, and inevitable things like oil spills and pollution and things like that. So right now, the United States has not ratified the Law of the Sea, and our topic is going to advocate that they should. The second international treaty that our topic is going to talk about is the Rome Statute of the International Criminal Court, often abbreviated as the ICC. This is the technical name for the treaty that founded the International Criminal Court. This court deals with 4 different things: genocide, crimes against humanity, war crimes, and crimes against aggression. Again, we'll get into this when we talk about the history and background. I don't really think definitionally these things are going to be argued. Just going to give you a brief little background into what exactly this thing is. I think that the last part of the topic that's interesting is the and or nature of the topic. I think that the reason that this is interesting is that, unlike a lot of traditional debate resolutions that we have, I think that a lot of affirmatives on this topic are going to choose the or part of the topic and either read their affirmative about the Law of the Sea or about the International Criminal Court. I think that this means that a lot of negative teams are going to have to be prepared to debate both of these, because if the affirmative is just about the ICC, your negative about the Law of the Sea probably doesn't make any sense. I do, however, think that the concept of treaties is kind of the unifying concept of this topic, and I think that if you approach the topic from a holistic perspective, that your cases from both sides could probably be pretty similar. So I think that this is a brief little intro to the topic and how the topic is going to be defined. I think that a really simple way of thinking about it is just that the Senate is going to ratify 2 different treaties. We'll get a lot into that, what that means, in a second when I talk about treaties and history and background, but that is a brief little introduction to the topic and the definitions. Now I'm going to talk about treaties and how they work. So as I've been saying, I think the unifying concept of our topic is treaties, and I want to stop off and talk a little bit about how treaties work from a process perspective, from how the United States ratifies treaties to treaty powers to all sorts of things like that, before we talk about the specific treaties that our topic talks about, because I think that this knowledge will benefit you when you debate about the topic. So a treaty can be called a number of things. So in our topic, the Law of the Sea is the United Nations Convention. A treaty can be a treaty, a convention, a pact, a protocol. It is an international agreement. In our topic, we are going to talk about multilateral treaties, specifically on the global scale. So a treaty that is not between 2 countries or 3 countries, but an international treaty that's between all of the different states and parties and countries on the earth. I think that the first thing to talk about with these treaties is that they are very formal. They are written kind of like a research paper that have every nuance dotted and teed out so that you know exactly as a country what this entails. If you look at, for instance, the Law of the Sea, it is a 200-page document that codifies exactly what all of these specificities of the treaty mean. We'll get into that in a second, but it is very formal and it is also an agreement that states come to. If there is this big document but nobody agrees to it, it's not a treaty then, because a certain number of state parties have to ratify that treaty in order for it to come into force. So the last concept is that it is legally binding. It forces the state or the party to the treaty to abide by the things that the treaty says you should do. We've been talking about this in my classes, and the concept that's kind of like the rules that you have for a classroom, that people won't talk over each other and things like that. If people don't agree to that, if there's no way to enforce that, if there's no punishment mechanism, there's no way to be able to have these treaties mean anything in the first place, rather than just being some kind of like face value, look at what we have done. If we look at treaties as a process, it first starts with a negotiation. This 200-page document for the Law of the Sea did not come out of nowhere. It came out of a long negotiation process where lots of countries sat down at the table and bargained out, negotiated out what exactly they were going to be beholden to via this treaty. After that process, the countries all signed off on this convention and took it back to their home countries. So you'll see a lot of language that talks about how states have signed treaties in the past but then pulled out of them. That is an example of a treaty that has not been ratified, because the ratification process is when the Senate or the Congress, when we look at the United States, actually votes on whether or not this should be done. We'll get into what this specifically means in a second, but one of the things to note is that the negotiation process is done by the executive branch. It's done by the president, so the president is tasked with this negotiating process, but then the Senate has to be the one who approves it. As a part of this approval process, there is this thing called reservations. These are caveats that the Senate can add to say, we don't want to follow this part of the Law of the Sea, or we don't want to follow this one of the four parts of the International Criminal Court, so we're going to amend it or modify it. And a lot of times in the language of treaties, you hear this called RUDs, but I don't think that these are going to be as big of a thing on this topic, which we'll get into in a second, but just note that this is a part of the political process for the ratification process for treaties. Once a treaty is ratified, note if it's not ratified, if it doesn't get enough votes, it just doesn't become a treaty. But if it does become a treaty, it enters into force. And there's two different concepts to this. One is called self-executing, and the other is called non-self-executing. I think for the context of our topic, that both of these treaties would be self-executing, because they wouldn't require any additional legislation in order to be implemented. They would just, we would join the treaty and have to abide by the different conventions that are in the Law of the Sea, or the different statutes that are a part of the International Criminal Court. The last part of this is that there are enforcement mechanisms for the treaties. Not going to get into a lot of that now, but just note that, there has to be some way to guarantee that the people who have ratified, the states that have ratified, follow through with their commitment. The specific process for how this works in the United States is that there is a treaty clause in the United States Constitution, Article 2, Section 2, Clause 2. And like I said before, the president is the one who negotiates and signs the treaties. So the president, or, probably somebody on behalf of the president, somebody who they have assigned as the negotiator, maybe the UN delegate, I don't know, something like that, will negotiate the treaty and sign the treaty, but that treaty doesn't enter into force until the Senate actually votes for it. So after that whole negotiation process, the Senate will vote on it. The Senate will strictly say yes or no, it will approve or it will disapprove. The thing that is really important is that this is not like typical legislation where you have to get 50 votes plus the vice president or 51 votes. It is a situation where it has to be a 2/3 supermajority. So the reason that these treaties probably haven't been passed already is that it requires 67 votes in order to enter into force. If you do not get 67 senators, note that this is just the Senate. The House has nothing to do with treaty ratification. That's how many votes you need. If you get that many votes, the law becomes the supreme law of the land. It is essentially written into the Constitution, and ratification essentially incorporates that treaty into U.S. federal law. It is literally just like the Congress passed a bill. It becomes U.S. law. If we look at treaties in general, before we get into our specific treaties, there's lots of different treaties. If you were to just Google treaties that the U.S. has ratified or treaties that exist, there's hundreds of them. There's lots of different ones that are going to be important in the context of our topic, because people are going to talk about the ICC or the Law of the Sea juxtaposed to things like non-proliferation treaties like START or the Montreal Protocol or the Paris Accords or the Geneva Conventions. So it is probably worth looking into these things in order to get a better understanding of how different treaties work. This is definitely outside the scope of this topic lecture, but there's lots of different examples for how other treaties work in treaty law as well. But when you look at treaties specifically, a lot of treaty literature is going to be based around international law. The reason for this is that become a party to makes you responsible for something, and that makes the state adhere to different rules or norms or principles, different standards that state has to respect and that other states have to respect, and that level of mutuality is really important in international law in terms of respecting the environment, human rights, different customs, humanitarian laws, different aspects to international law. So I think that the reason that this topic lecture is not quite what I thought it was going to be, in terms of just they're kind of just being two topics in one, is that treaties and international law is really a unifying concept for how to put these two treaties together. Now, that being said, I want to jump now into our specific treaties, starting with the Law of the Sea. Before I talk about the Law of the Sea specifically, I want to talk about some background and history that kind of informs how the Law of the Sea came about. If we look at the early history of where the Law of the Sea is based, we can look at the cannon shot rule. This is basically, in non-modern times, you would put a cannon on the shoreline, and if you fired a cannon into the ocean, where the cannonball land would be the national territory of that specific state. That is generally recognized now as about 3 nautical miles, and that territory would be the national territory of that specific state. Anything beyond those would be international waters that would be free for all nations, ships to travel, and things like that. Now, it would also be kind of a free-for-all for pirates and things like that, but that's beyond the scope of what I want to talk about right now. There's other maritime laws that are based in trade. If we look back in ancient Egypt, they were one of the first states to have maritime laws, and they were based on having safe trade from port to port in order to have fair trade once a ship arrived at that port. Simply said, these maritime laws allowed for free trade in ancient Egypt. This was also the same case in the Byzantine Empire, where you see different sea laws that allow for the uniform treatment of different ships. So the reason that you would have this is it would allow different countries to, or different states or different individuals to have uniform treatment in terms of trading with different parties. You will also see this in Italy and Spain with the Consulate of the Seas, the Codes of the Seas, very similar concepts. In the United States, I don't think this will be a part of our topic, but just in terms of how maritime law works, there is something that was passed in the 1920s that still exists called the Jones Act. And the Jones Act is really interesting for how it regulates maritime trade within the United States with different requirements like it has their trade from a U.S. port to a U.S. port has to happen, for instance, on a U.S. built ship with a U.S. flagged crew with all sorts of different aspects like that. I don't think that that will be a part of our topic, but it will be interesting to see if that becomes an aspect of it, because a lot of the ways people will approach the law of the sea is based on free trade. If we look at the law of the sea, specifically, this convention starts in 1973. You'll remember from sort of the Treaties 101 section that there's a process that these treaties go through. So this treaty, the law of the sea, this convention was negotiated starting with President Nixon and happens through 4 different administrations. So the 9 years that it takes happens through the Nixon administration, the Ford administration, the Carter administration, and then ends in the Reagan administration. So these treaties take a long time, but something that's interesting is while the U.S. is not a current party, it has not ratified the law of the sea, it was the lead negotiating force. It was kind of like the chief party that made this treaty happen. So I think that, maybe you could get some hypocrisy arguments from there, some credibility, some leadership arguments, but that's interesting to note. This convention results in a 200-page document that you can look up, you can Google it, it's very accessible, that countries signed in 1982. So it took 9 years to create this document, and like I said, it goes through 4 different administrations, and by the time it hits 1982, Reagan is the president, and Reagan at the time thought that the United States would not become a party to the law of the sea and had different objections to it. In 1994, in November, the law of the sea treaty took effect. Basically, as a part of this treaty and as a part of the ICC, it takes 60 countries ratifying the treaty in order for the treaty to become a thing, become into force. And it took effect in 1994. So it took functionally 12 years in order to get those 60 ratifications. If we look at the present day, there's currently 170 parties to the Law of the Sea Treaty. So as we'll see in a second on the map, the United States is one of the only countries that is not party to the Law of the Sea. And it's worth noting that there was an amendment to the Law of the Sea. So in 1994, the deep seabed mining kind of objections that the United States had with the law of the sea was amended to make the United States, to kind of give the United States what the United States wanted. And the United States still did not become a party. So I think that that is something that some teams will talk about. I think that if we look at this map, it will help illustrate that there's 170 parties, Russia, China, the EU, all parties to the law of the sea. Non-parties listed here. You'll note that there are a couple of landlocked countries that haven't ratified it. I assume that's potentially because they don't care. But as we'll get to in a second, that might not make sense because there are some economic rights, funding type sharing agreements that exist that would potentially behoove them to join. But the United States is not alone. There are a bunch of other countries that are not members of the Law of the Sea or haven't ratified the Law of the Sea. Something that's worth noting is that the United States, for the most part, follows the Law of the Sea. So 95% of what's in the Law of the Sea, the United States already does. The United States Navy, for instance, I believe follows the Law of the Sea, all sorts of different aspects like that. So I think that it's going to be interesting for the affirmative on this topic to try to generate some offense as to why specifically ratifying the Law of the Sea is sort of worth it or important because, for instance, if we look at a South China Sea scenario, for instance, all of those countries are already part of the law of the sea. So that's going to be something that the Affs is going to have to sort of deal with. I think that the law of the sea covers way more than I could talk about in this video, but I just want to give you all some ideas for different arguments that you could potentially read on this topic. There's a lot of literature that talks about different territorial waters and exclusive economic zones. I'm going to have some pictures about what that looks like in a second, but that's basically the law of the sea creates international norms for what different countries' territorial rights should be, whether that be where your ships can be, where your economic resources can be harvested, all sorts of different aspects to that. The law of the sea also encompasses the freedom of the seas and the freedom of navigation. This gives, for instance, the U.S. Navy ships the ability to go on the high seas wherever they want to. It also has regulations for when a ship can be boarded, when it can be interdicted, all sorts of different things like that in order to, potentially stop things like drug trafficking or smuggling or human trafficking, but also there is an additional aspect to the law of the sea called the Proliferation Security Initiative, where there are also regulations and a regime for regulating weapons of mass destruction smuggling, nuclear proliferation smuggling, nuclear weapons smuggling, fissile material smuggling on the high seas. There is a completely different aspect to the law of the sea where there's different environmental regulations that have to be followed. There's a mechanism for suing based on these environmental regulations, whether it be from oil spills to all sorts of different environmentally regulated things like resource extraction, whatever it may be. There are different tribunals and dispute mechanisms. There is a forum for this to be dealt with. I will talk a little bit about that later because there's a lot of specificity for how this works. There's 4 different dispute mechanisms. I think that some teams will talk about this in terms of right now the United States has no rights to file disputes because they are not a party. Maybe becoming a party means that the United States can resolve some of these disputes, but I think that that's something to be seen. I think that there are a lot of teams that will talk about the deep sea mining part of the law of the sea. I will talk about this separately when I talk about the affirmative section. There will also be a lot of territorial questions, whether it be the South China Sea, the Arctic, or the 2 places that a lot of teams have gone in the past when the law of the sea has been debated. But basically, what are the apportionment of rights of the ocean for different countries? And that is what we are going to look at with the law of the sea component to this topic. You will note with this sort of sovereign rights and boundaries that are created that there's different zones and different rules that are based off of sort of legal language that was negotiated. So if we look at your territorial sea covers 12 nautical miles, your contiguous zone is 24 nautical miles, and your exclusive economic zone is 200 nautical miles. And there's different rules and regulations for what you can and cannot do in these different places. You'll note from the picture that's way above me right now that, there's also different ideas of when does that start? How does an island affect that? How does an atoll affect that? If the coast curves, how does that affect that? And there's all sorts of arguments and regulations over this because of how things are worded in that specific document. So a lot of people will likely talk about China and the South China Sea and different regulations with the 9-dash line, all sorts of things like that. I think that while this looks very complicated over here on the other side with different countries having different ideas of where their territorial sea starts versus their exclusive economic zone and how they overlap and how that works, when I was looking at this, I thought that if we looked at the Arctic up here, that the Arctic is even more complicated because there's more countries and it's divided up in a different fashion. And I think that this is really a reason why this topic is a thing, because it behooves sort of humankind to regulate the ocean to prevent disputes from happening. I also have this secondary graph up here that's kind of different from the one on the page before, because there is also something called the extended continental shelf, and the idea behind this would be that by the United States joining the Law of the Sea, the United States would probably massively increase its territorial holdings. I've seen a lot of literature that said that if the United States joined the Law of the Sea, the amount of like sea-based territory that we would gain would be greater than like the Louisiana Purchase. So I think that this is something that's really interesting, especially if you are going to talk about deep sea mining and things like that. Again, not going to talk about things like the Seabed Authority because that's going to come later, but this is a general idea of what the Law of the Sea encompasses as a convention or as a treaty. The last thing that I want to note is that the Law of the Sea is very complicated, and I don't think that people will necessarily debate this, but, you know, there are different ideas behind what a reef is, what a rock is. If the rock is exposed at low tide on the seaward side, that means something different than if it's not exposed, if it's exposed as an island versus a reef versus a rock versus an atoll. And these are all very complicated things that mean different things that could influence how things like the South China Sea are debated. Because, you know, if a certain rock is up at low tide, that might mean a country's territorial sea claims could be different based on how that works. And with climate change, with the sea level rising, that could also change things. A different style example of this is the idea of innocent passage. So there's different norms and rules and duties behind this for different ships, but the idea is that you as a ship are allowed to pass through another country's territorial sea as long as you do that in a continuous and expeditious fashion on the surface. So there's some questions for the United States as to how this might deal with our submarines or remotely operated UAV type vehicles, because there are rules that would force those vehicles to operate on the surface. But the good aspect to this that I think a lot of literature will talk about is that this allows for innocent passage through places like straits and sea lanes that allow for international free trade to happen, which makes me think a lot of people might use this part of the Law of the Sea to talk about the economy and free trade and the passage of ships. And I know that this is a huge thing for a lot of different industries, not just shipping, but and trade, but, you know, fishing, for instance. I know when you go fishing out of San Diego, a lot of times you are allowed to go through the Coronado Islands in Mexico, because if you go through and do not fish and you just have innocent passage, you are allowed to do that, and that saves your trip several hours instead of having to avoid the entire Mexican territorial sea. The interesting thing to note is that these all have different relationships to the freedom of navigation. And one thing that I haven't talked about yet, but I think a lot of people will look at, is that while this has been very much based in the ocean space so far, in ships and underwater, that this also applies to airplanes and airspace, and that the Law of the Sea also covers airspace. So it deals with airplanes having safe passage or innocent passage, being able to go through different places, different straits. And I think that some people may also talk about that when they talk about the Law of the Sea. But that's pretty much what I have for the Law of the Sea. Now I want to move on and talk about the ICC. The history behind the International Criminal Court is much briefer than the Law of the Sea. The basic idea behind the International Criminal Court is very similar to the Nuremberg trials, where the United States, Great Britain, France, and the Soviet Union, the Allied powers, came together to form an international military tribunal. And between 1945 and 1946, different leaders from Nazi Germany stood trial for crimes, whether it be war crimes, crimes against humanity, etc. So that's the basic idea behind the International Criminal Court. It was signed or adopted in July of 1998. You'll note that it's called the Rome Statute of the International Criminal Court. The reason it's called the Rome Statute is that it was adopted in Rome. The United States has signed but not ratified the International Criminal Court, and it took effect 4 years after it was adopted, when 60 countries ratified the International Criminal Court. The thing that's important to note is that it is not retroactive. So any crime that took place before July 1st, 2002 cannot be tried by the International Criminal Court because it is not retroactive. You will often hear the International Criminal Court referred to as The Hague because that is where the International Criminal Court is based in the Netherlands. The problem with this is that there are a lot of other organizations that are based in The Hague, so you have to be very, very careful when you are doing your research about the International Criminal Court. One of the problems with the International Criminal Court is that it has no standing police force, no army, nothing like that. It has a simple detention center. It can just simply issue things like arrest warrants, and pretty much entirely relies on the states that are party to the Rome Statute of the International Criminal Court to enforce the laws of the ICC, or to simply arrest the people that it issues arrest warrants for. If we look at the Rome Statute for the International Criminal Court, this is pretty much just the legal name for the treaty that created the ICC. There are 4 different aspects to the International Criminal Court. Basically, the International Criminal Court is viewed as a court of last resort. The court would much rather the national jurisdiction or the national courts of the countries deal with these issues, but if they do not, the court is seen as a last resort for issues of genocide, war crimes, crimes against humanity, and the crime of aggression. These are changing in terms of they can encompass different things. So if you look at the actual wording of these, there is a very specific terminology. There are very specific things that encompass war crimes or crimes against humanity, but you'll note that these are kind of changing and evolving over time based on the scope of the world. So for instance, the arrest warrants that were issued for Benjamin Netanyahu of Israel talk about the crime of aggression, but specifically talk about the war crime of starvation and how that works as a crime against humanity, and I think is something that has never been used in international law or with the International Criminal Court before. So there are very changing in different aspects to what the interpretation of these different things that are covered under the ICC sort of entail. Some sort of logistical notes. The chief prosecutor of the ICC is Karim Khan. There are 18 different judges that are that kind of compose this court. They're all from different member countries, and there are 3 ways that a person can be investigated. They can either be investigated by a member country referring them to be investigated by the United Nations Security Council, and by the prosecutor's own initiative, by the chief prosecutor saying we should investigate this based on their own will, and that is called proprio motu. And something that is interesting to note is that a country cannot be investigated. A crime cannot be brought against a country. It must be brought against an individual. What will happen is that there will be a preliminary investigation that is done by the ICC, and they determine whether or not an investigation should be opened up against that individual. If they choose to do so, then arrest warrants are issued for that individual, like they were for Putin or Netanyahu or for different other leaders, whether it be in Africa or other places in the past. You'll note that the idea behind this is that these people will be arrested in order to stand trial. When that trial happens, it requires a conviction from 2 of the 3 prosecutors. There's no jury. There's these 18 judges. So there's 3 judges. If you appeal that decision, it's a 5-judge panel. One thing that I want to note is that while we talk about all these technical things, the ICC is not the International Court of Justice. That is the top UN court that's also in The Hague, which is pretty confusing for a lot of people. But please note that these are different things, and that the ICC itself is not affiliated with the United Nations. So some important things to note. The ICC is a little less I'm not going to say as popular. It's a little less adopted than the Law of the Sea Treaty. So you will note that there's a lot more countries who are not members of the ICC, like Russia and China, India, Turkey, Iran, Saudi Arabia. So there's large portions of the globe that are not party to the ICC. So maybe this, unlike the Law of the Sea, will be a place where the U.S. ratifying might actually lead to more benefits, or might lead to something happening, because it's not as adopted around the world as the Law of the Sea agreement. I also think that maybe you could have different advantages, different contentions based around U.S. influence causing one of these other countries to join, if the United States joined, or something along those lines. The point of the ICC is to only hear the most serious crimes that meet a standard of gravity, and there are different procedural ways in order to determine gravity that I will not bore you with, but the ICC is seen as a court of last resort. It does not want to replace the national state courts of a nation. It wants to complement them. But as time has gone on, the ICC has sort of widened in scope to include sort of environmental crimes and gender persecution under what would be included under crimes against humanity. So I think that that is important in terms of the scope of the ICC, because I think a lot of people may get ground based on those arguments. Note that, again, the court tries individuals, not countries, and there is a whole process for how this investigation happens. The court itself, right now, a lot of current issues will revolve around Israel and Russia. This is simply because the court has issued arrest warrants for different people that have caused different countries to react in different ways. There's also some questions as per the efficacy of the court, whether the court is a good idea, whether the funding is really worth it for how much money comes from it. Maybe the court needs more funding. I think there's all sorts of different aspects to the ICC in its current composition that teams could take in order to generate some offense in the debate. You will note, though, one of the reasons that the ICC part of the topic is I wouldn't say frustrating, but kind of just nonsensical, is that very soon Donald Trump is going to become the president again, and Trump is very opposed to the International Criminal Court. And the idea that the Trump administration would ratify the Rome Statute of the International Criminal Court is certainly a use of fiat, in the sense that it is definitely something that would never happen, at least from the signs that we have seen in the present day and in the past from the Trump administration. Like, we are talking about an administration that literally like sanctioned the chief prosecutor of the ICC, and I think that the idea that that his administration would join the ICC, would definitely generate some unique links to maybe some international law scenarios, but also might generate some links to just something that sort of doesn't make any sense. But I guess that's the nature behind why we debate these utopian policies that may not happen ever. The last thing that I want to note in this history section before we get on to the specific arguments on this topic is that, like many topics, we have debated this topic before. If you go to the Open Evidence Project, for instance, for 2014 for policy debate camps, there's like 10 Law of the Sea files that you can download. It was a very popular affirmative on that topic. Like I said, it was negotiated from 1973 to 1982. It's been around for 40, 50 years. The arguments haven't necessarily changed. While I'm not advocating for you to just go there and steal all the evidence, I think that might be a good base level place for a lot of teams to start, because the core idea behind those arguments hasn't really changed in the last 10 years. But there have been all sorts of different times in the past where either the Law of the Sea or the ICC has been debated, whether it be at a college policy level, high school policy level, or in PF. The thing that's interesting to note about these topics, at least from a wording perspective, is that they say accede or ratify and not become party to. And like I was saying in the definition section, I think that will be an interesting angle for a lot of teams to take in order to try to defend against process style counterplans that the negative is sure to read on this topic. But I'll get more into that on the counterplans section. Now I want to start to talk about the actual substance of the topic, starting with value criterion cases on this January-February topic. In terms of value and criterion, I suspect that an overwhelming number of teams will likely just read a util-based framework. And the reason for this is I think that based on how they're going to interpret the topic, I think that people are going to definitionally define the topic as something that a policymaker ought to hypothetically implement. Therefore, that policymaker has to look at what the cost benefit of the world of ratifying or not ratifying one of these two specific treaties is. I think that because of this, you will have a lot of teams that just kind of do policy debate where you will have a util-based calculus for deciding the debate. While I think that an overwhelming number of teams will likely do this, I think that there is definitely some ground to read some value criterion cases that are outside the realm of utilitarianism. I think that the first one of these would be a case that revolves around the idea of cosmopolitanism, saying that the United States has to ratify this treaty and do it over its own national interests because the United States is not its own separate thing and rather a collection of humans that make up sort of citizens of the world rather than citizens of a particular nation state, and it is our cosmopolitan duty to do something like the Law of the Sea or the International Criminal Court. I think that in terms of the Law of the Sea, you might see a lot of people talk about the commons, the ocean as a commons for all of humanity, and use a framework that fits within those types of guidelines. I also think that you may see people look to sort of a social contract theory that states that the people or the United States are obligated based on an agreement between what they have done in the past via negotiating the Law of the Sea or being a part of the International Criminal Court in terms of signing it but not ratifying it. I think that those would be interesting to make in terms of having a framework based around the social contract theory, and that we need to look at sort of the authority of all of humanity over the rights of some specific people in order to protect all of society. I also think along some similar guidelines that you will have some value criterion cases that talk about autonomy and justice, and specifically in terms of the ICC, we might see this more, whether it be a genocide framework, which I'm going to talk about in a second, but just that that this authority of the ICC is justified because it makes autonomy of specific individuals possible that is not possible without this international court enforcing things. I also think that you may have frameworks that are along distributive lines. So if we look at the law of the sea, I know I haven't gotten to the International Seabed Authority part of this yet, but the deep sea mining part of the law of the sea requires a certain portion of the profits or the taxes or whatever it may be go to a fund that is divided up amongst different countries. I think that this might be a framework that a lot of teams use to talk about distributive justice in terms of everybody getting equal access to the ocean and the benefits and the resources that come from that. I think that people might use a distributive theory to look at the resolution from that perspective. I also think that this is a pretty good Kant topic. I think that there are a lot of different aspects to international law and international legal theory that have a connection to Kant and talk about how international law and domestic justice are intertwined. There specifically is a part of Kant that talks about just states and unjust states under international law. I think that there could be an argument to be made here that in order for the United States to become a just state, it would have to join or become party to the law of the sea or the International Criminal Court. I also think there are going to be interesting frameworks here based on sort of the ICC and how different populations are subordinated and how that would make a country an unjust country. I think that there's also a layer to Kant that's going to talk about sort of the perpetual peace and how the nature of things ought to be peaceful. It's going to talk a lot about the territorial integrity, maybe the law of the sea, lots of different aspects to Kant that you could talk about here. Again, lots of things. The last thing that I want to talk about for value criterion cases is I think that you will again see people talk about Rawls and about Nozick or about libertarianism. I think the reason for this is that the law of the sea specifically talks a lot about property rights and taxation, and I think that some people who are negative might take a Nozick-based framework again where they say no to those things, where a Rawls-based framework would say the opposite. So I think maybe you will see some affirmatives use a Rawls-based framework. I also think that Rawls could be an argument or a framework that is very interesting to be set as a standard on this topic, because when you have affirmatives that advocate for things like the prevention of genocide, I think that they might use things like the veil of ignorance or the difference principle to say, hey, if we use the veil of ignorance to say that that like you could be the individual who is having this crime against humanity committed against you, or is part of a group who is having genocide committed against them, that under a Rawlsian framework would violate these principles, and that if we would look at a rights-based or a right-to-life-based framework, that we need to take that sort of value when we look at the round. I think that there's definitely more value criterions that you could read, but I think that this is a pretty good sample of things that people could say. I do, however, suspect that a lot of teams are just going to default to util and debate the consequences of whether or not the law of the sea or the ICC is good or bad. Let's jump right into the Affs side of the law of the sea, different advantages, different contentions that I think you can read if you want to read the law of the sea part of the topic as your affirmative. First, I think there's two territorial places that a lot of affirmatives will talk about, the Arctic and the South China Sea. Starting with the Arctic, I think that there will be an economy aspect to this where teams will say there's legal uncertainty now that comes from the United States not ratifying the law of the sea. That causes a lack of economic utilization, whether it be oil, natural resources, shipping lanes, and that the United States needs to ratify the law of the sea in order to allow for Arctic resource development. I also think there will be a second layer to this that will involve climate change, where people may say that the Arctic is heating up, there will be unexplored places, they might even talk about the Northwest Passage, and that we need legal certainty through ratifying the law of the sea in order to access those things. I also think that a second level to this is that people will make arguments about conflict in the Arctic, and that this will resolve tensions that are specifically created from climate change opening up areas that were no longer accessible. May talk a lot about Russian relations and Russia containment and different layers to that. I think that the last layer of the Arctic that you will see people talk about is the environment and protecting the Arctic environment. For the South China Sea, I think that teams will talk about how ratification resolves different disputes in the South China Sea, and that it specifically gains the United States diplomatic credibility. Specifically note that a lot of parties in the South China Sea, a lot of states are already party to the law of the sea, so you would need to have some type of link here for the affirmative that says that the U.S. acceding will cause China to comply or will dissuade China from territorial expansion along the 9-U line that I showed in the lost portion of the history section. I think that something to note here is that maybe there'll be like a China relations part to this, but a lot of these countries are already members, so that's an interesting thing to note, or an interesting thing for negative teams to note, because that might be a way to mitigate this. I think that an interesting level to this that some teams might take is that we've seen arguments about island building in the past. I think that a lot of teams might use that in order to talk about the South China Sea. I think that you will also have teams talk about freedom of navigation and the maritime commons. There will definitely be a military angle to this, but I also think that people will talk about this from the level of just trying to stop drug trafficking, whether that be through freedom of navigation in order to track these things, or through things like overflight. Remember that the freedom or that the law of the sea encompasses not just a maritime commons, but also an aerial commons. So I think that that might be an angle that some people take. There's the Proliferation Security Initiative. I think that there will be a certain angle to that. I also think that there will be a free trade component to this, because remember that the freedom of navigation also allows for the right of passage through international straits, and that innocent passage might be important for free trade happening between different countries. The next part of the topic that I think people will talk about, I've grouped into talking about, or I've labeled it the continental shelf, but I think you could also label this the EEZ, or the exclusive economic zone. I kind of glossed over this when I talked about Lost earlier, but remember that the Law of the Sea Treaty creates this 200 nautical mile exclusive economic zone where that territory would be exclusive use, exclusive economic rights over the country that has the claim to that. So I think teams will use that in order to make energy resource arguments. I think that there will be an overlap with the Arctic part of the topic here, where people will talk about oil drilling and natural gas and things like that, but there in the past have been arguments about Atlantic oil too, and I also think there will be arguments about offshore wind that will be important here. I think that teams are going to have to make an argument as to why ratifying is important, because obviously these companies that would do natural gas or oil or offshore wind could already do these things now. But I think that affirmatives would have to say why that legal framework would create sort of a certainty in order to drill, and that would be the access point that you want to have if you're reading this style of advantage on the law of the sea topic. The second portion of advantages that I want to talk about is the International Seabed Authority. This probably should have been in the introduction to Lost section, but I think that this is going to be its own thing, because this is one of the things that, or aspects to the law of the sea that we don't get access to right now because we haven't ratified the law of the sea. The International Seabed Authority determines the rights to seabed mining. So a lot of teams will say deep sea mining and have different aspects to that. If we look back, that deep sea mining could be for renewable resources, could be for rare earth materials or minerals, where they're talking about, whether or not the United States has enough of these resources, or whether it has to be dependent on other countries. And I think that people will read manufacturing advantages or mining contentions based off of this. But the key access point to this is this International Seabed Authority. I think one of the reasons why I think this will be an important aspect of the topic is that right now, this Seabed Authority is pretty much run by Russia and China. And the only reason that is the case is because the United States has not ratified the Law of the Sea. If the United States ratified the Law of the Sea, the United States, via the negotiation that take place for the convention, would have an unequal privilege where the United States would have veto power over everything that the ISA does. And I think that a lot of teams will use this to generate offense for the affirmative, because they will say that Russia and China are overfilling their role now. The United States needs to join the ISA in order to counterbalance this, and we'll read scenarios based on national security, property rights, things of that nature that are unique to why the United States ratifying the Law of the Sea is good, and something that wouldn't link to the status quo doing that action now. So I think that the International Seabed Authority, as a link to deep sea mining, REM, manufacturing, all sorts of things like that, are going to be an important access point for affirmative advantages on this topic. I also think that you will see affirmatives talk about the International Tribunal for the Law of the Seas. I also talked about in the intro that there are dispute resolution mechanisms. This is one of them. It is based in Hamburg. I think that people will try to read links based off of this dispute resolution mechanism to try to resolve things like global warming, because I have read evidence that says that that the Law of the Sea links climate change and the Paris Accords to the ratification of the Law of the Sea. So I think that, because a lot of people will try to read global warming based impacts, that this will be something that affirmative teams will gravitate towards saying in the debate. I think that you will have teams for the Law of the Sea say economy-based arguments, whether that be from technological advances, scientific cooperation or research, mining, the commercial use of the seas, just like a generic free trade advantage like I've been talking about. I think that there's a lot of ways that the affirmative can access the economy. I'm not sure it's like the strongest access point, but if you want to say the economy, there's definitely ground for you on this topic. I think there's a second scenario that people will read that's just like scientific research or scientific cooperation is good. I think that this is a place people have gone in the past with these topics. I think you will have just sort of your generic environment contentions. I've already talked about this with the Arctic, but I think we'll get this more in general with pollution, with oil spills, with mining, creating bad things because of the after effects of the mining. I also think you'll have arguments about people talking about plastic pollutions in the oceans, all sorts of things like that. You will definitely have affirmatives that also talk about fishing. There's definitely parts of the convention that talk about overfishing and fish stocks. The problem with this versus like the Seabed Authority arguments is that all of these countries are already party to the Law of the Sea, so it would have to be something very specific about the U.S. depleting its own fish stocks. So I think that this is kind of an example of sort of the sort of line the affirmative has to trend on this topic. There would definitely be arguments about piracy, providing humanitarian relief, all sorts of other parts of the convention. I think that the last part of the Law of the Sea, and you're going to see this for the ICC topic as well, I think that a lot of teams are just going to take this up as a leadership, hedge good, hedge bad, multilat good, multilat bad, unilat hedge good, unilat hedge bad topic. And I think that that is a pretty good angle for you to take on this topic. I think the leadership contention is probably real good on this topic, that the United States ratifying the law of the sea would kind of sustain a rules-based international order, that the law of the sea would kind of be this legal strategic weapon that the United States could use to gain credibility. It would increase kind of our multilateralism, our credibility, our international legal standards, and would kind of blunt the current negative reaction that the United States has worldwide. I think that a lot of people will take different aspects towards how leadership works. I also think that there will kind of be a hard power leadership style affirmative advantage that says naval power is important. The law of the sea codifies all of these navigation and overflight rights that our Navy would have, and that the high seas aspect, the high seas freedom parts of the law of the sea are essential parts to how the Navy operates in order to globally make itself mobile to all regions. Now, the problem again is that the Navy already does this, so I'm not sure how ratifying it is like a super unique thing, but there's definitely literature that talks about how the law of the sea is important to the United States' standing in the international order, and that our lack of ratification creates this kind of anti-U.S. order that counters U.S. rules. Think about it. If all these countries are already a part of the law of the sea and we aren't, it's pretty easy to think about how you could view that as a coalition that counters the United States. But there are also, on the other end of that, sort of unilateral hedge benefits to this topic in terms of the freedom of navigation. The military would definitely like the ratification of the law of the sea because it would allow for the critical protection of military vessels, of naval vessels. It would allow stable freedom of navigation for the military, and would allow the Navy a lot of flexibility to operate in territories that it may not have access to. People might also talk about navies cooperating with one another, whether that be, diplomatically between the United States and a different country. I think there's a lot of ground there. I also think that people are definitely just going to say international law. I kind of grouped this in with leadership. You could argue that it's separate. I think people will make all types of arguments about international law. You can do your own research there. There's a lot that that encompasses. The last part of this is, I think people might talk about the United Nations here, talk about why ratification is important to the United Nations credibility. You might also have some teams talk about why it's important for the Constitution or for the rule of law of the world. The last thing that I want to note on the law of the sea before I move to the ICC is just a bit of caution. I know I've been noting this, but the U.S. already follows most of the law of the sea. All these countries already follow the law of the sea. So you need to think as the affirmative, how does the U.S. ratifying the law of the sea drastically change things when all of these countries are already party to the law of the sea? So if I were making my contentions on this topic, I would want reasons why the U.S. ratifying is specifically important. What does ratifying it specifically do that changes the status quo from a scenario where the United States already follows most of the law of the sea? I think this is why a lot of teams are going to make arguments about the ISA, because it is something that the affirmative can have sort of a unique solvent scenario for. So just some advice for you when you approach the law of the sea. Now I want to talk about affirmatives with the ICC. I think the ICC part of the topic is a lot less cumbersome than the lost section. I think this can be easily divided into a couple of categories. I think the first category is just reasons why the International Criminal Court is good. I think there will be different links into this argument, but the idea would be is that the U.S. ratifying the court would somehow make the court successful or make it legitimate where it is not now. I think that there are a lot of different reasons that you could read for an ICC good style contention. A lot of them would be based around the four different aspects that the court tries, whether it be genocide, crimes against humanity, war crimes, or the crime of aggression. You will have different access points to different violence scenarios. I think people will kind of treat this like the democratic peace theory argument, where they will just say prevents violence more than causes violence, resolves conflicts, create peace, things like that. I also think that you will have a style of this affirmative that talks about genocide prevention. I could see this kind of being its own thing, which I'll talk about in a second. I think that you may see scenarios that talk about human rights and human rights credibility and norms. You'll definitely have different scenarios that talk about drug trafficking and terrorism, because that has been something that has been interpreted to be underneath of the ICC. I think that you will also see people who try to interpret the ICC in a broader sense. So on the college antitrust topic, I found cards that talked about using the ICC in antitrust litigation, in crimes against the environment. I think all of these things might be places where the affirmative tries to gain some broader access points to a part of the topic that is probably a lot more narrow in nature, at least for teams that are trying to make util-based arguments. I think that the specific cases of the ICC are going to be a place where teams go. I think the first place is Russia. The ICC has a standing arrest warrant for the president of Russia, Vladimir Putin. This is based off crimes of aggression, I believe, that are based off the war in Ukraine. I think that people will say that the United States joining sort of resolves that somehow. I think that there's a lot of alternate causes that teams would have to deal with, but I think that that's definitely something. I think that the other place that will be popular in terms of specific cases will be Israel. The criminal court issued an arrest warrant for Netanyahu, who is the prime minister of Israel, also for the former defense minister of Israel, as well as some other people. I think that this will be a place that a lot of people go. I think that there will be different arguments for this on the affirmative and the negative. I think that one of the things that's interesting about this topic that I didn't mention in the lost section is that you can kind of link turn everything that the affirmative says and say it as the negative on this topic. So for lost, for instance, I think that teams will say South China Sea as an affirmative argument and a negative argument. And I think this is true with a lot of these different cases where you will see teams say Africa on the affirmative, but you will definitely see teams say Africa on the negative, where teams are talking about specific cases, but based on their interpretation of that case, they will either say that's a negative access point or it's an affirmative access point to that argument. So I think that there's other places that people will go outside of Russia and outside of Israel. I've seen literature about Myanmar, about Sudan, about Venezuela, about a bunch of different countries in Africa, which I'll talk about on the negative. But I think that people may try to get more specific in order to garner some util-based scenarios in the debate. For the last part of the ICC, I definitely think it'll be similar to the law of the sea, where you will have international law-based advantages that say the U.S. is hypocritical now because we are not a party. Becoming a party means we resolve that hypocrisy, which is important for the rule of law, international law, democracy, all sorts of things of that nature. I also think kind of in line with the ICC good arguments, you will have people say that the U.S. joining makes the ICC credible, makes it solvent, fixes problems that the negative is going to probably bring up if you choose to argue about the ICC as your affirmative. I think the last layer to affirmatives on the ICC is that you will definitely have affirmatives that just read genocide is bad, you cannot be conditional towards genocide, and just have that be their affirmative in the debate. I think that that will be incredibly strategic, and you may see other affirmatives do this for the environment or gender-based violence or child soldiers, and just say that there's some moral obligation to reject these practices, and that's what the affirmative does. I also think that you may have some affirmatives claim justice for specific victims. So the ICC is one of the only international courts where the person is not just prosecuted, but justice is brought for the victims of that crime. And I think that you could see some advantages based off of that, based off of human rights credibility, things of that nature. So that's where I think that the ICC part of the topic is going to go. Before I talk about planned affirmatives, or the lack thereof, I want to stop and talk about traditional debate for a second and just give traditional debaters a warning that you really need to contemplate how much topic knowledge does your judge actually have? How much topic knowledge can you assume your judge has? I think unlike the past two topics that we've had where we have talked about wages and taxes, things that are very relatable to judges who are parent judges or judging for the first time, or school teachers who do not have sort of this technical jargon ability to understand these topics, I think that we really need to consider how we talk about these topics. I like to talk about the dinner table test. Is this something that we would talk about at my house if it was discussed at the dinner table? So I don't know how other people's houses work, but I would assume that most average citizens of the United States don't have a background knowledge in the law of the sea or in the International Criminal Court, because these are very technical international things that do not relate to average citizens on a typical day-to-day basis. So I think that this means that a lot of traditional debaters are going to have cases that explain what these things mean in technical terms or in very simple terms, because a lot of judges are just not going to know the specificities to what you're talking about. And if you start talking about the minutia details of the law of the sea or the criminal court in a very fast manner that assumes your judge knows things, the case is going to be that they probably don't. So I just want to stop off and give traditional debaters a warning that your cases are probably going to have to look a little different on this topic than they have looked in the past, because you are probably going to have to instruct your judge more about the substance of the topic than in the past. Now, flipping over to planned affirmatives for a second, I really just don't think that this is a great topic for planned affirmatives or affirmatives that defend some type of specific action. I think that you will see three major affirmatives: one that has the U.S. ratify the law of the sea, one that has the U.S. ratify the ICC, and one that has the United States ratify both. I think that the way that I at least interpret become a party to means that there's probably not multiple ways that you could become a party to this topic, because become a party means that you likely have to affirm or ratify that whole treaty. I think that the way in which the law of the sea, the ICC are currently composed, that I'm not even sure the United States could place reservations or have some sort of partial ratification, because there's already so many other states that are party to these treaties. So I think that unlike previous topics, there's very little room for planned affirmatives on this topic. I think that this means that affirmatives are going to have very specific defenses of their advantage areas. I think that this topic, more so than others, you are likely going to see a lot of teams read process-based advantages, whether it be based on congressional power, treaty power, things like that, because in order to defend the process or the mechanism of the affirmative is likely going to need to have something like that in the AC. I think that you may see teams gravitate towards saying the courts. I think that is probably more of a negative argument on this topic, but it would not shock me. The reason for this is that people are going to have to defend the process of the affirmative and not just the substance of the affirmative in order to protect themselves against counterplans. So while I do not think there are going to be many affirmative plans on the topic, just because there really just isn't the ability for the affirmative to do so, I do think that you are going to see lots of different takes on what an affirmative on this topic looks like based on either the strategy in that specific debate or just the strategy that a specific team has in terms of how they think it is best to defend the topic, whether it be from a substantive angle, from an agential angle or from a process angle. So I think that looking at this, not from a plan perspective, but as a way to defend your mechanism, your process, your agent, is more important on any topic than ever. So that's pretty much what I have for planned affirmatives. Probably disappointed if you're coming to this section, but I think that this is just the nature of how this topic works. You have two options, an or an or. You get to choose between the two. So, planned affirmatives. Flipping over to the negative side of the ball, I want to initially note that the contentions and the ideas that I have up here are a lot less robust. There's a lot less contentions than there are for the negative, and the pretty simple explanation of this is that most contentions, the affirmative says, the negative can also says. For every article that says property rights is good, there's an article that says property rights is bad. For every article that says it's good for the environment, the Arctic, the South China Sea, there's articles that says it's bad. The same is true for the military. So please note that every contention for the law of the sea, the ICC, there are things that go in different directions depending on how you want to look at the topic. If we start, however, by looking at the negative for the law of the sea, I think you will have people who want to say economy contentions read links that are based off of a number of things. I think that you will have arguments based off royalties, so the seabed authority taxes countries that choose to have oil or gas or natural resources in their exclusive economic zone. You may also see economic links based off of lawsuits that are created from pollution, from environmental concerns. You will probably have whole cases that deal with the tech sharing, the proprietary tech sharing that has to happen. This new technology that corporations may use in order to exploit natural resources or on the deep seabed for mining would need to be shared with other countries. They would also need to have their revenues taxed and pay certain fees to the ISA. All different aspects to this will be ways that the negative will make economy arguments, but probably also have access points to other contentions that make these style of arguments in the debate. I also think that you will have arguments that just say the UN is bad just because it's the UN Convention on the Law of the Sea. People conflate the two and just say that the bureaucratic concerns of not just the Law of the Sea, but the convention itself are bad, that they misallocate funds, all sorts of things of that nature that indict the solvency of the actual organization itself. I think that, as I've been saying, people will also just say we're already a member as a way to mitigate a lot of these scenarios that the affirmative is going to go for in these debates. I also think that a lot of negatives will talk about the military, just like the affirmatives are going to talk about the military. There's different rules for how submarines have to operate. So for instance, if a submarine is in another country's territorial waters, that might be a thing that impedes the Navy's ability to do things. There may be tech transfers or tech sharing that's involved that involves sensitive military technologies that the United States doesn't want to deal with, or the testing of new technology platforms or new military platforms like remotely operated vehicles or unmanned vehicles are all different aspects to why the military may not agree with this. I also think that you may see the flip side of the freedom of navigation, where people will argue that it's a perception of the requirement of the law of the sea to suspend all military-related activities while conducting innocent passage. And I think that there will be different layers to how negatives deal with this, whether it be it hurts the U.S.'s ability to do things in other countries' waters, or it causes other countries to infringe upon U.S. waters that cause those things to happen. I also think you will see teams read terrorism scenarios. They'll say that being a party to the law of the sea makes it harder for the U.S. Navy and Coast Guard to interdict different things at the port, whether it be shipping containers or weapons of mass destruction, and that this high seas authority might be something that the affirmative has to deal with in the debate. I also think you will have different environment scenarios, whether it be that the offshore drilling natural gas, oil will lead to bad environmental consequences, hurt the biodiversity of the area, but there also might be, military disadvantages to this. So specifically, offshore wind, a lot of it has happened in the past in the Gulf and in Virginia, in areas where the military operates a lot. Maybe this will change the way our military has to operate in certain areas. I think that people will read access points to deep sea mining and how that specifically is an area of concern for the negative environmentally. Flipping things over to the International Criminal Court, I think that a lot of negatives for the ICC may talk about sovereignty, that the criminal court impinges upon the sovereignty of the nations who join it, that it gives the ICC too much prosecutorial power and makes it so that, for the U.S., for instance, the U.S. has very specific due process laws. If the ICC is a court of last resort that can try people who our due process laws don't work for, that might be something that is problematic at a sovereignty level. I also think that there are concerns about whether or not the court has political biases. There's questions to the impartiality of judges that all make it potentially questionable from a negative perspective. You will see that there's not just the United States who has this concern, but China, India, Israel. There's all sorts of different layers to this. I also think, as I mentioned on the affirmative side, I think that you will see people just say the ICC causes conflicts more than it prevents conflicts. It'll be similar to like a democratic peace theory debate where they will say, the ICC prolongs conflicts because the leaders don't want to surrender. They will only surrender when they are internationally issued an arrest warrant and actually arrested. I think that that might be an access point for a lot of negatives for the ICC. I also think that there will definitely be some type of military intervention or humanitarian intervention contention for the negative. I think that people will say how the U.S. will be afraid that their troops or whatever personnel they send into a region will be persecuted. Therefore, they won't send them in the first place. Therefore, we'll have negative aspects for security, national security, terrorism, the military power projection, all sorts of things like that. There's a really good historical example here, if you want to research it, that talks about how U.S. personnel in Afghanistan was potentially going to be prosecuted over war crimes that were committed. This is one of Trump's beefs with the ICC, and that might be a place where you want to do research if you go down this avenue, because I think that there will be a lot of existential style impacts for teams who want to say util on this topic. I also think with the ICC that you are going to see a big conflict or a big solvency debate. I think that just from a general perspective, the International Criminal Court has very little authority, very limited jurisdiction, is kind of inefficient, kind of ineffective. So I think that affirmative teams are going to want to try to resolve these things, but negative teams are just going to say the U.S. ratifying doesn't resolve these things and just makes it so that we're a party and there's not really any benefit. A really good example to this is that Hungary is a party to the ICC, and when Putin visited Hungary, they should have arrested him because there was an arrest warrant issued by the ICC and Hungary as a party, but they didn't do so. So there's lots of problems with how that process might actually work, whether it be from countries just straight up not following or not listening, whether or not it's like at a court level. So, there's issues of potential political interference in the court itself, pressure from different nations and different leaders to do different things. There isn't a great deal of transparency in how the court itself acts. And I think that this is an aspect that a lot of negatives are going to take, because I think the negative for the ICC is probably going to be pretty successful at proving that the court is not as independent as the affirmative wants it to be. It's not as objective, and its investigations are pretty inconsistent. And I think that this is going to be a really good access point for negatives to just not say solvency arguments, but use that solvency argument to mitigate the affirmative while making these kind of increases conflict, causes conflict, and having those kind of roots cause style debates to begin with. I also think that for the ICC, you may see a lot of negative contentions that talk about Africa. The number of investigations and arrest warrants that have been disproportionately targeted towards Africa is astronomical. The court almost exclusively, up until Russia and Israel, has issued decisions and cases dealing with Africa, and a number of articles that I have read say that there aren't a lot of voices from the global south and from Africa on the court itself, yet this Western developed court is issuing all of these investigations of African countries where they themselves do the same things. So I think that a lot of literature in that sort of sect of the literature is going to be important, not just to read like disadvantages or things like that, but I think a lot of critical negative ground might be gained there. I also think that people are going to read potentially like some Constitution style DAs here, like I talked about in the prosecutor, the last section, that there's some due process concerns, there's some power concerns, and that might lead to some people reading some, constitutional rule of law style disads. I can also see people reading arguments about sanctions. It's important to note that after some unfavorable decisions, I think specifically the Afghanistan troop personnel question, that President Trump sanctioned the ICC, like sanctioned the chief prosecutor, and I think that some negatives might garner ground based off of that, because the affirmative just says we have to ratify it, doesn't say we have to like follow through once some decisions are made. So I think that the negative might have some ground there. I think that the last place that I want to talk about is that it is for the ICC, is that I think a lot of negatives will potentially use Israel as their main contention. The reason for this is that it's late breaking, it's in the news, there's lots of articles that talk about it. There's lots of articles that say the United States would stand by Israel no matter what, and I think that there is really good ground that, maybe the U.S. supporting the ICC would isolate Israel, would help resolve Middle Eastern war, things like that. I haven't necessarily seen that article yet, but I think that it is certainly an interesting aspect to the topic, and I think that if a team were to get ahead on this portion of the topic, it's going to be hard to beat them because they're just going to be ahead. And that's going to be hard for the other side to deal with if you aren't at the same level of expertise or at the same level of up-to-date cards as the other side. The last thing I want to note is that there are some claims against Karim Khan, the chief prosecutor of the ICC, in terms of sexual harassment and sexual misconduct. So I could definitely see some negative teams making some arguments there. I know that this negative section was really specific to just the ICC or the law of the sea. I think that there's not as many generic disadvantages on this topic. The two places that I would kind of point you, one would be the politics disad. Remember, the way fiat works, you would be fiating at least 67 senators. Vote yes. There's a lot of cards in all sorts of directions that I think that the politics disad would be really good here. I think it's specifically good because the party that's about to be in power, the conservatives, the Republicans, are generally the party that does not want to do these things. But there is broad public political support. So I think that this is an interesting angle. The other aspect to this is that Trump is about to become president. So I think that teams that utilize that might not only use it to read the politics disad in a very specific way, but also to to kind of make solvency arguments. Note that because of the ratification nature of the topic, the links to the politics to set are going to be probably Senate based. So you're probably going to see some more agenda disads and things along that line. The last two thoughts that I want to leave you with for disadvantages is I think a lot of teams or a lot of debaters that are going to be successful on this topic are just going to approach it like an old school hedge topic. I don't think it matters if you're from a big school or a small school. I think you can get way up to date on this hedge good, hedge bad, I-law good, I-law bad, multilat good, multilat bad, unilat good, unilat bad, and that, between 1 to 3 people working together, you could update that over break, over whatever it be, that there's no team that could beat you on that argument. So I think that I view this topic very much as like an old school hedge U.S. leadership topic. And if you view it that way, no matter what the Affs says, no matter what the neg says, you're going to be able to say one of those things that I just mentioned. And if you can get on top of that, you can probably win a lot of debates. The second thing that I want to talk about is that from a logical perspective, this topic makes no sense. So Trump would probably never join the ICC, and we've been trying to ratify the Law of the Sea Treaty for 40 years, and we haven't been able to do that. So I think that negative teams that talk about durable fiat, how that really works, is that really a thing for how we view the world with Trump? Sure, we can ratify it. Is Trump going to follow through with things? Is he going to circumvent the policies from happening? Are we actually going to follow through with the things that we say we're going to do once we ratify the treaty? And I think that while this is certainly outside the scope of this video, I think that teams that take a hard look at what durable fiat is, what circumvention is, how our affirmative it can actually be solvent, are not just going to be important from a policy debate perspective, but I think it will help a lot of critical negatives generate a lot of offense in this debate off of sort of how this role-playing fiat thing that we're imagining might not be as real world or as educationally beneficial as we want it to be. Now, that being said, there's obviously a lot of benefits to debating this substance. It just, from just looking at it from a real world perspective, this is definitely a topic where fiat is necessary because, it just probably wouldn't happen in the real world. So that's what I've got in terms of the negative contentions, the disadvantages, things of that nature. Now I want to flip it over and talk about the rest of the negatives arsenal on this Treaties, ICC, Law of the Sea topic. The next two sections on both counterplans and on topicality arguments are going to be pretty brief. The reason for this is not because I think people won't read a bunch of different arguments that I probably don't have listed here, but I just think that there aren't a lot of really unique counterplans or a lot of unique topicality arguments that are really worth noting. I think that this topic is pretty simple, and it's a pretty big case debate. I think that teams that do choose to read counterplans will do a couple of things. I think that first is that they may defend some other type of treaty, say that we should do this other part, this other treaty, ratify that instead, say that it resolves international law or whatever contention you say is, and then just say Law of the Sea or ICC is bad, call it a done deal. I think that while that might be a strategy that some teams read and that there will be a lot of style of counterplans that are read like that, I think that the wording become party to is very interesting on this topic, and a lot of traditional process style counterplans that we would see probably are not as competitive functionally and textually because of the words ratify and accede not being in the topic. I think that the problem is that people may try to read those style of counterplans, but I think that if they don't become party to the topic or if they don't become party to the treaty, then they probably don't solve whatever the affirmative is going to try to go for in the debate. So I think that teams will try to make different arguments and try to sort of change the word become party to ratify or accede, claim that it's technically different, claim that it's certain or uncertain or immediate. I think that while these arguments aren't great, they just aren't great on this topic too. I think one of the specific places that you could see people go are congressional executive agreements. A lot of literature says that this could be something that could be an alternative to ratifying the treaty. However, this wouldn't ratify the treaty. So if the affirmative just had an advantage based on ratification being good, I think that that would probably beat back this style of counterplan. But you will have the signing statements process style of counterplans that you have on any style of these topics. Might see the court's counterplan pop up. I foresee some process counterplans being a thing, but I think that teams that specifically wield this become party to phrasing in a useful way will be successful in beating back a lot of those counterplans. I do foresee people saying bilateral or trilateral counterplans. So for Law of the Sea, for instance, we'll do Law of the Sea, just not the whole agreement. We'll only do it with Russia. We'll only do it with China, and then claim some sort of difference or net benefit based off of that. I could see people saying the ICJ instead of the ICC. Hopefully they're not saying the ICJ on the Affs because it's not the ICC. I could also see in affirmatives that say and, so in affirmatives that say both Law of the Sea and ICC, I could see the negative picking out of one of the two of those, which is probably why you should just choose one and defend it. But I think that some teams will maybe even try to bait that strategy because they think that they have some angle to beat that counterplan. I think that while this is probably a smaller sample size of counterplans than are traditionally in these topic lectures, I think that that is probably just a symptom of this maybe not being the best counterplan topic out there. I think if we look and switch our gears to topicality here for a second, I don't think that this is the best like bare plurals topic. I think that the phrasing of and or means people are just going to pick one or the other most likely. I think that people may read some arguments about the United States and treaties, meaning that ratification has to come from the Senate if people try to read like courts affirmatives or something like that. I do think that a lot of affirmative teams need to think about the T become party to argument, because if you think that the affirmative gets to say reservations or amend the Law of the Sea or do something that excludes one of the four parts of the ICC, I think that the negative team is probably going to be really successful in saying that become party to means that you can't do something like that. So I think that that will be utilized in terms of a topicality argument to keep the affirmative in check. I think that this could also be used in sort of extra or affects T debates to say that the affirmative can only become party. They can't do anything that is extra to that or claim things that come beyond that. So I think that that will be where I see the negative going. I now want to flip the ball over to the critical side of the topic. I want to finish up by talking about critical arguments on the negative and on the affirmative. I want to start by saying everything that I'm going to talk about in the critical negative section could probably also be read as a critical affirmative. So if you think that I don't say as much in the critical affirmative section, I would just use the negative section as a way to create your affirmative. I think that the first style of critical negative arguments are just going to be critiques of international law. I think that they're going to critique how treaties work and how that they secure state power over whether it be humans or animal life. They create this legal system that codifies Western thought rather than the thought of the global South, and that the idea behind international law and treaties is a Eurocentric imperial notion that comes from nations that already have power. I think that there's a lot of different ways that people will talk about international law, whether it be from a feminist standpoint, whether it be from a black standpoint. I think that there will be different layers to this depending on how you choose to read your negative arguments based on what interests you. I think that for the court specifically that there may be arguments about Agamben and Foucault that talk about how the criminal court creates this state of exception through arrest warrants and through its prevention of different war crimes. I think that settler colonialism is also going to be a very, very interesting argument on this topic. I think that a lot of teams are going to employ the set call critique. The reason for this is that the history of treaties is generally not very good with indigenous people. I don't think the United States has ever kept a treaty with indigenous people, despite having over 500 of them. While you may say this doesn't relate to the law of the sea, I think that this is very indicative of the treaty process as a whole, where the idea that the ICC and the law of the sea don't allow for indigenous voices. They only allow for state-based powers to affirm the law of the sea. Did this process consult how indigenous peoples, whether it be in different Pacific regions, the Arctic, all over the world, how their rights are impacted when they didn't even have a seat at the negotiating table? Different indigenous groups are going to view different aspects of the topic differently. There are different ways in which dispossession works with the marine biosphere, with oceans. Different indigenous groups have different interpretations and ideas of what that means. There also may be some set call arguments that talk about airspace and how that interprets the topic, and how the access point for the affirmative advocating for these things is just new rules that whiteness has created for sovereignty in terms of, territory, whether it be land or whether it be the ocean. A lot of these property rights questions will definitely be in the literature for settler colonialism, and when we specifically look at terms like the exclusive economic zone, the idea behind that is kind of baked in colonial history, because it assumes that this state-based power should have the exclusive economic rights of this region, where, originally those rights were not held by the United States or another group, but by indigenous groups, and that the idea of these state-based treaties sort of leaves no room or papers over the idea that indigenous people have rights to the same territory that countries have proclaimed for themselves. I also think that along this same type of critical ideology, that people will talk about the concept of borders, geography, spatial control of the ocean. As I talked about in the law of the sea portion of this, there is definitely the idea of, territorial sea starts here, there's a border, different things have different meanings. I think you will definitely see people critique that. I also think that you will see these from an airspace perspective. I think that in terms of the ICC, you might also see this, because the ICC generates sovereignty over areas that it wouldn't already have control over, which would kind of reify all of these notions. You might see that tied into how the ICC historically has been anti-African. I also think that you will see a lot of environment-based critiques. I think that, maybe it won't be the anthropocentrism critique of the yesteryears, but I think you will definitely see like environmental securitization or environmental managerialism. I think that the law of the sea definitively would have great links to environmental managerialism with how the international authority systems are set up. You will definitely see different aspects to sort of the ontology of water, the fluidity of water, and how that works. I think you will see, ecofeminism, eco-apocalyptic rhetoric, maybe some more specific versions of the security K than just the generic security K. But I also think for both layers of this topic, the ICC and the law of the sea, that, just the generic security K could go at lengths on this topic, whether it be, the affirmatives portrayal of China or Russia in the Arctic, or how, different countries are portrayed in the ICC. I do think that people will say cap, will say neolib. I think that there's lots of great arguments here. I don't really want to go all in depth on that, but I think with like the resources and the ocean development and the facilitation of free trade, that it's kind of just choose your flavor, choose what you want to do. There's definitely not only like a cap bad version of this critique, but definitely like a neoliberal ideology version of the cap K critique that could be really good on this topic based on how you want to choose how you read the cap K on this topic. I do think that there are some really good blackness or anti-black arguments on this topic. I think Agatha Angelou is incredible on this topic. I think if you're interested in that you should just stop and go read that. I think Gums is really good on this topic. I don't really want to develop too much more here just because this video is already almost 2 hours long, but I think that those are places that you should go if you want to say sort of critical black arguments on the affirmative and the negative. I also think that you will have sort of, I'm not going to say object-oriented ontology or like Baudrillard, but I think that critical negative teams as well as critical affirmative teams are going to be really behooved to think about why the concept of fiat on this topic is so silly. It's going to have the Trump administration join a treaty or join a criminal court that it is vehemently opposed to, a law of the sea treaty that the United States has never joined. I think that critical negative teams are going to try to poke fun at these concepts of durable fiat, the ideas of circumvention, to try to generate a lot of their link offense for how either it is try or die for the critique or the critical affirmative, or just how these framework arguments that the negative or the affirmative is going to try to go for are just silly in the real world, and that the type of education that we are gaining, sure, fiat is meant to try to get rid of these, hypothetical questions, but when it's really this utopian for something that the United States would never do, sure, fiat resolves the link, the affirmative gets durable fiat, but, what happens if the U.S. joins the court and then sanctions it? Or, I just think there's all sorts of questions that are outside of the scope of this topic lecture, but I think that teams that look at that not only from a critical perspective, but from a policy perspective, are going to be really, really successful in mitigating a lot of the things that the affirmative wants to go for at the end of the debate and make these kind of like try or die for the negative arguments. I think briefly for critical affirmatives, again, I think it's going to be a lot of these critical arguments that I just talked about just on the affirmative instead of the negative, and then you're going to have to figure out how you're going to deal with framework in the debate. I think that you're going to see a lot of affirmatives, potentially try to use these circumvention durable fiat arguments to their advantage. I do think that two different affirmatives that I could potentially see are, I think you will have some critical genocide prevention affirmatives that are going to be interesting with how the court functions. I also, if you are interested in critical black affirmatives, there are definitely a bunch of different affirmatives on the oceans topic from 2014 that you can go and check out. There are a bunch of different affirmatives that talk about the middle passage in terms of how ocean and water is related to that, and use the analogy of the wake that you see in Sharp's literature to talk about the topic from a black perspective. And I think that you will definitely see, based on just the history of debate and things that people have said in the past, I think that you will see those affirmatives be really strategic on this topic. So that's what I have from a critical perspective, and that's what I have in terms of the entirety of the topic lecture. Hopefully y'all found this helpful. Hopefully this increases your knowledge on the topic. Hope it gets you some wins on the topic, and look forward to seeing you in a future video. Thank you. Bye.